NACDL is the association of the nation's criminal defense bar.
I do think we need to take a moment and wonder how police happen to occupy the massive presence that they do in our culture. I mean, Radley Balko in Rise of the Warrior Cop thinks it's not even constitutional, that it's violative of the Third Amendment, which I didn't remember what it was until reading Radley Balko's Rise of the Warrior Cop. But this is an organization that's completely racist in its origins. The very first police stations were the slave patrols in the South. We somehow have agreed to surrender our will on command to police officers, despite the fact that we may not respect their manners, that they don't have our interests at heart. These are law enforcement agencies that are supposed to police themselves, but instead immunize people who commit horrible misdeeds. And when we, the general public, demand evidence of those misdeeds, they go to great efforts to hide that information from us. Our courts have spun from the days of Bivens, which sought to promote accountability, to the days of SB v. County of San Diego, Casella v. Hughes, White v. Pauley, which essentially hold that if a police officer beats, shoots, tases, maims, tortures, or kills someone, they're immune from suit, provided that the manner in which they beat, tased, tortured, or killed someone has never been examined by a court and found to be unlawful. That is the present tense. We've allowed ourselves to allow these people to suck millions, if not billions, of much-needed community dollars to arm domestic soldiers to engage in violent attacks against nonviolent offenders. And still, we afford these guys a shroud of credibility and reliability when they walk into the court. So this is what we're going to talk about. We're going to talk about that shroud of credibility. Then we're going to talk about preparation, what you need to do for cross-examination before the very first juror walks in for voir dire. Then we're going to talk about setting up that cross-examination during voir dire, and then during opening, and then cross-examination techniques. So let's begin talking about how strange our job is, how for some reason it's fallen on us to prove to a jury that police officers are human, and that they're fallible, and that they're prone to exaggeration and bias just like the rest of us are. Now in the 1950s, I think there was racist police, but in the non-stressed communities, there was a very different perception of police officers as the sort of hunky-dory guy that was there to make sure everything ran smoothly. How many public defenders do we have here today? Okay, fantastic. That's amazing. I'll tell you what, I'm going to give a gift. I'm going to give a membership to NACDL to the first public defender who comes up to me after the presentation, tells me I'm great, and actually means it. I just want you guys to know that. But when I talk about public defenders, I think that our generation, it's a very liberal definition because I include myself in that, we were formed by different images of police, and they were a lot harsher. They were images of violence.
Don't pull it out. Don't pull it out. Don't pull it out. Okay.
I got it, Jim.
And it wasn't just images of violent attacks on nonviolent offenders. We would hear stories about police corruption, about Rambart, about incredibly abuses of power, even in the sexual context. And then when I began working in officer shooting cases, you began to learn about catchphrases that were used and just passed around to actually excuse murders. Now, in the Dontre Hamilton case, we had an expert named Will Harmoning. And he came on board and he said, listen, you have a close combat case, so there's going to be 4 defenses that are going to be used. And by close combat, I mean this. According to Susan Ford, the witness that was 10 feet away, Christopher Manny came up to a sleeping Dontre Hamilton, kicked him, patted him down illegally, which was decided by the courts. They got in a scuffle, and then he backed up 10 feet. He dropped to one knee. He pulled out a gun, and he shot Dontre Hamilton 15 times. Okay? And Harmoning says, look, they're going to hit you with 4 defenses. The first is going to be he was reaching for his gun because no one can challenge that. The second's going to be he had a 1,000-yard stare. which they always use and I actually believe is code for black. Then they said he had superhuman strength, because only he can challenge that, and I also believe that that's code for black. And then he said, I feared for my life. And I feared for my life became a catchphrase that officers continually use to excuse murder, and it's passed around even in faraway shootings.
Recently, former Minnesota police officer Geronimo Yanez, who shot and killed black motorist Philando Castile, said that he was afraid for his life and was just trying to protect himself.
The reason my client Jason fired his weapon that evening back in October 2014 is that he truly was in fear for his life as well as the lives of his fellow police officers.
I feared for my life. That's what Officer Alex Olson told Chattanooga Internal Affairs investigators about the night he fired his weapon responding to a traffic stop.
How did you protect and serve Sam DuBose that evening, Mr. Tennessee? I protected my life.
We have learned the officer who fired the fatal shots feared for his life as well as the...
But essentially, it wasn't just these stories of violence. It wasn't just these stories of corruption. It wasn't just these passed around catchphrases to excuse murder. They still get this shroud of credibility, and I don't understand it. I mean, perhaps it's because, the Nixon administration and every administration since prepared this war on drugs, and they sort of sold the idea that the drug dealers were coming for your kids, and these police officers were the grand protectors of those kids. Now, the first line of defense, that's their job. But perhaps we perceive them as that thin blue line that separates the us's versus the them's. I think it might be because they look like the popular guys in high school. They're the beefy, and they have all these gadgets on them, and they walk into the room, and I think people want to be aligned with them. I think the fact that we're used to submitting our will to police outside of the courtroom spills into the courtroom. And they're glorified on TV shows. Does anybody have any other ideas as to why we may give them this shroud of credibility and this shroud of reliability? Anyone? Oh, that he says we equate them with members of the military, and that people think that they're ultimately soldiers. And I can't tell you any others. Well, let me tell you, I think that the worst day in our country's history, and perhaps also sadly the most opportunistic, was this day. And after this day, people conflated firemen with police, but all of a sudden it became un-American to challenge the credibility of a police officer because juries began to see police officers as this. And then it fell on our shoulders to prove that these heroes are unreliable. So how are we going to do it? Well, we're going to begin with the golden rule. And the golden rule is it's not about cross-examining the cop. It's about cross-examining your specific cop. And you're going to get to know that cop, all right? So now it's time to do your preparation. And the first thing, this is an advanced seminar. You all know how to do this. It's a detailed client interview. You're going to talk about the who's, the where's, the why's, the when's, the when's, the what, if he knows the officer before, and how credible is your client. But the second thing is something that we fail. We tend to delegate to our investigators, and we can't. Nothing is more important than the site visit. And if you're a public defender, and I used to go alone to Compton, and I did a case in Baltimore. It was terrifying. Now I go with investigators, but we need to know the lay of the land, where the officer was, where our client was, what obstacles may have been in between. We need to know what stores are there. We need to know what windows are looking down, what possible obstacles could be blocking their view. So that way, if we know the lay of the land better than the officer and we're cross-examining them, that's going to bolster our credibility with the jury. Now, complaint histories. We got to get these and we got to follow up on them. And in some places, they're really, really hard to acquire. In California, we have the stupidest process in the world. It might be unconstitutional. It's called the pitches process. I have to write down my defense. I have to give it to a judge. The judge then reads my defense under seal, and then he decides whether or not it implicates a category of officer misconduct. And if he does, I get hits, but I don't get the witnesses or the content. I just get the name and the last known contact information. But if you can track down one of those witnesses who filed a complaint, that is fantastic. I brought in a case, and it was an excessive force case. There was a witness who was 10 years old, and he'd been beaten terribly by a man named Ivan Guillermo. I'm going to talk about Ivan Guillermo a lot. And I brought in, and he talked about the trauma of being beaten when he was 12, about beaten when he was 10. He remembered it clearly. Guillermo had a stock answer. The prosecution's cross-examination was, well, you shouldn't have stole those flowers anyway, which was amazing, and that totally alienated himself to the jury. You can also, this is really easy, put your officer's name into PACER. and look for defendants in his 1983 actions or Bivens actions. And then call the plaintiff's counsel, because I tell you, if he has anything, he's going to want to share it with you. Lawyers love to talk about our victories. We do. And if he's gotten any dirt on this person, he's going to talk to you. He's going to give you transcripts. He's going to tell you everything he possibly can. And hopefully within there is something that you can use. Now, I've been doing this lately. I'll be honest with you, it hasn't taken me anywhere, but I'm going to keep doing it. You have an independent right to get information on any government entity. So you can get, and there's an application in your written materials. You get out a Public Records Act request or a Freedom of Information Act request, and you might get more, because we're entitled to any kind of paper in any industry that we pay taxes for. And yes, there's a law enforcement exclusion, but if you read it, it doesn't apply to complaint histories. So get these out. It takes 5 minutes, and hopefully you might hit some pay dirt. Look at other state laws. In California, we have this fantastic new state law called the Right to Know Act, where as an individual, I have a right, just my right, to find out complaint histories and disciplinary records for any officer. Now, this is being heavily litigated right now. The police officer unions are saying it's unconstitutional, that it violates the privacy rights of the police officers, of the complainants, that they would have appealed, blah, blah, blah. And certain agencies, such as Inglewood, which is fantastic, are shredding their records. But other agencies are actually turning this stuff over, which is amazing. Now, if you have the resources, look for civil case records, especially in no-fault states. Go through divorce records and custody records if you find your officer, because there might be some affidavits that make horrific allegations of alcoholism, of domestic violence, of child abuse. And if you can get the affiant's name on a witness list, that very well may preclude your officer from testifying. The easiest thing in the world is to do a Google search for your officer. We forget that. And if there's great information about them, write that down. You can use that as well. If there's terrible information, that's even better. Now, how many people have been burned here because your client thought it was a genius idea to put the fruits of their ill-gotten gains up on Facebook? Anyone want to tell a story? Anyone? Stand up. What was your worst? Fantastic. Now, it might not have been the gun, right? That's your defense. It might have just looked like the gun that was used, which I had the same case, and it was a gun that was used in several murders. But don't worry, my client wasn't holding it. He had his 2-year-old niece right on his lap, and she was holding the gun. So that was fine. But here's what's kind of amazing. Police officers, until they get busted, they have Facebook accounts too. Okay, and I had a civil case where I got destroyed, partly because I was way overeager. I mean, what happened was that they were doing police were doing a vice, sting in an area, and my client, who was mentally ill, came in with a ski mask, and they did exactly what they're not supposed to do to mentally ill people. They rolled up on him, and he reached in his back pocket and pulled out a half bottle of James Dean and went, "Die!" It was on video, and they shot him, and I decided to sue and lost a whole bunch of money. But nevertheless, I did win one single battle when I found on that day the use of force expert, a guy named Ed Flossie. He travels around. He says, no matter what a cop did, it's totally fine. And this was on his Facebook page. Police lives matter. Police lives matter. Defend us in battle. And I got to ask him, who are you in battle with? And it was a wonderful, awkward moment. I lost the war, but I won this battle. Ask around. We totally forget to ask our colleagues if they've ever, cross-examined any one of our officers, or put it on the listserv. Because again, if someone has some transcripts, they're going to want to save it. We're seeing the emergence of local police accountability projects, like Legal Aid Capstat, where they've scoured 1983 actions for dirt, and it's searchable, and they have now accumulated data on 3,900 officers, and it's publicly searchable. Now, there's Chicago has another one. I think it's called, I don't know the name, I just heard about it, but it's also searchable. Barry Scheck is trying to develop a national database for the same reason. And if we can share dirt on our cops and share information on our cops, that may actually preclude so many cops from being able to testify. All right, now what's the first question that they ask your expert? In any case, how do they try to establish that your expert is biased? What'd you say? Getting paid, right? How much they get paid? That's fantastic. If you want to get dirty, governmental payroll data is usually publicly accessible information. And I've used this. This is Ivan Guillermo, the officer I can't stand. I cannot tell you how freaked out officers were When you start talking about, hey, you don't say how much did you make that year, because everyone will object, the judge will let it know. You come out with, last year you made $149,813 in compensation and benefits. Now, how many public defenders do we have here? Is that a lot of money or is that not a lot of money? I mean, that's more money than most of your jurors make. So it really catches them off guard, so take it and be willing to use it if you got it. So now you got all your dirt and you're ready to go. All right, before your juror comes in, before you do your cross-examination, you're going to prepare how to use this impeachment evidence. Now, of course, the best way is video, but that's incredibly hard to come by. That said, there was this guy in Los Angeles, Stephen Graff Levine. It was fantastic. Body cam footage was just being used. He picked up a little simple case with drug possession and a gun possession. And then he saw some stuff that was pretty compelling on the body cam video. So here was the police report. Officer Lee recovered a green baggie containing off-white powder substance from Shields' front left pocket. So that's what the jury's going to think of, right? He was patting him down. He stuck his hand in. He found cocaine. But this guy Levine had some different information. So he locked Levine into that story during his cross-examination. Not the way I would do it, but an effective way. Tell me what you found. Found a baggie with white powder-like substance, sir. You found it using your hand, correct? Yes, sir. Once you found that baggie, was there anything else in his pocket? Do you recall? I don't recall. What did you do with it? I gave it to Officer Sherrock. So now the jury's ready, right? They know the officer patted the bad guy down, reached into his pocket, found the drugs, handed it away. But then this happened.
Officer Lee is seen here searching the suspect. He testified in court the same as what the police report shows, that the cocaine was found in Shields' front left pocket. But the video shows an entirely different story that brings up even more questions. Watch this angle from the beginning. LAPD officer Gaxiola picks up Shields' wallet from the street, shows it to Officer Lee, who points to the suspect as if to say it's his. He puts it back down, then steps on the street, bends over and picks up a small bag with white powder. It eventually tested positive for drugs. He goes back on the sidewalk, picks up the wallet, and motions to Lee, and appears to put the bag in the wallet. Now, if you're wondering why anyone would allegedly do this while being recorded, this could be the reason. You hear the audio and saw the officer's hand. That's when he actually activated the recording on the camera. But what he may not have known is that the previous 30 seconds is automatically saved without audio.
Okay, fantastic. Now I got some great news about that case and some bad news about that case. The great news is, no kidding, the district attorney cried. She broke out and cried. She went up to him and said, "Why didn't you tell me?" He couldn't tell him. They would have fixed it. Here's the bad news. 3 weeks ago, I called the LAPD. I said that today, May 4th, I was doing a preliminary hearing, and I wanted to make sure that Officer Gaxiola and that Officer Lee were available to testify, and yes, of course they were. From what I understand, there was no internal sanction. There was no lawsuit because Shields had a subsequent problem and they threatened to arrest him if he brought a lawsuit, which moves forward to my concept that these guys are essentially bulletproof, which makes them able to get away with terrible things, which is why it's totally improper for them to have this shroud of credibility. So another great way to impeach is through third-party witnesses. But I can't tell you how more effective it is to have government witnesses rather than regular third-party witnesses. So I had a case that I was so happy yesterday when Posner talked about DUIs, because everybody's talking about murders and killers. I do a lot of DUIs, and they may not be as celebrated. But I had this DUI where the officer testified that he sent the same documents to the DMV that he did to the prosecutor. But there was that Romberg test, that guessing out of 30 test, and the ones from the DMV said, all right, 20 seconds out of 30, not that bad. The one to the prosecutor said, was whited out, said 90 seconds out of 30, and officer stopped the test. Now, if I went up to the officer and I said, what happened? He would have said, oh man, I'm sorry. You know, we cut and paste. I forgot to modify it when I sent to the one to the prosecutor to the DMV. But instead, I brought in the custodian of records from the DMV who totally freaked out. He was like, these are different. These documents are different. They're not the same. And all of a sudden, a little typo became a conspiracy to frame an impoverished Hispanic. And it actually worked. So if you can get a government witness to come in, and I think also the shroud of credibility we afford to officers once they're in can spill over to other government witnesses. Otherwise, third-party witnesses, and then the best is documents. Now, risky is through the officer. This is not a good story. This is a story how I lost. I had a Rene Enriquez case. I don't know if you know those cases. He's the guy's name's the boxer. He wrote this book called The Black Hand, where he talks about raping and killing and pillaging people, and it's pretty repulsive, and then leaving MS-13, and now he testifies for a guy named Francis Hardiman, and it's terrifying. They walk him in, they fill the courthouse with 60 deputies. The juror is absolutely terrified. Hardiman says he's neutral, and the boxer, Rene Enriquez, says your client sounds like a drug dealer or looks like a drug dealer, and they convict. And so I'm sitting there trying to figure out what to do, and they also use this as a discovery tool because they try to get drug dealers or whatever to give the names in the hierarchy of cartel members. But they don't want to do this for a very good reason, because they'd be killed. So my client took the stand. He said he wasn't a drug dealer. And then they started asking him, they show him pictures. Who's this guy? Who's this guy? Who's this guy? He doesn't say anything. The judge gets frustrated, leaves the stand, sends the jury to the box. Hardiman turns around and screams and yells at me. Did you know he was not going to give names? Did you know he was not going to give names? That is so unethical. That is so unethical. You could use a license. Well, great. Mr. Neutral just freaked out on me, so I throw Mr. Neutral on the stand right afterwards. I said, didn't you just have words with me over the break, say I should lose my license? He said, no. That's what not happened at all, officer. You came up to me and said, excuse me, sir, do you think what I just did was unethical? And I had nothing. I had absolutely nothing. It was just my own piss and vinegar that made me think I was going to beat, and nothing. So my solution now is I'm very afraid to cross-examine through the officer, and I certainly don't do it unless I have something to do some backup. The other way to do a good cross-examination, impeachment, is during closing argument. Setting something up. The officer, officer, you're sure that your view of Fifth and Olive was unobstructed, and you now know that there's something that's in the way of Fifth and Olive. So you're going to show the jury, that's not true because on June 14th, there was a chain link fence there, there was a couple of trailers there, blah, 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 but that's effective. So now you got all your dirt and you're ready to go, all right? Before you move forward, before your jury comes in, you got to define your strategy. Who are your enemies? Who are your friends? What style they're going to use? You want to get ready so you know what kind of jury you want to pick when they come in. Are you a public defender or court appointed? And will you tell the jury? Now, if you're going to tell the jury, don't ask the judge. He's going to say don't do it because it engenders sympathy, which it actually does. And lastly, you're going to write out your roadmap, however it's going to be. If you use a yellow pad with different ideas, that's fine. As a baby public defender, I used to write out verbatim every question I was going to say, which was a little ridiculous. I have friends, Todd Pugh, he does check boxes with all his issues, and he doesn't sit down until every box is checked. Whatever works for you, you've got your roadmap, you're ready to go, and in walks your first juror for voir dire, and they sit, and now you have to set up your cross-examination during voir dire, and you know what your goal is. You're trying to deselect jurors that are adverse to your theory and style. But here's the problem. Usually your theory is the cop's rotten or the cop's unreliable. And in most jurisdictions, they're pro-cop. Maybe not in Compton, maybe not in parts of New Orleans, but in most jurisdictions, you have pro-cop. And what are you going to do? You're going to try to flush out who's really dangerous, try to do cause wherever you can, try to line up the worst to the best, and use what peremptory challenges you can do, and that's it. You also have to educate and indoctrinate because chances are they're not going to read the instructions. They're going to say they are, but they're not. So you want to hit reasonable doubt, you want to hit bias. I always like to say you're supposed to consider witness bias. And by the way, that includes biased against blank. And I say blank, what group of people do you think cops are more biased against than any other group in the entire world? Anybody want to take a guess? Because I think you'll all agree. See, I'm hearing blacks, who? African Americans, good, I don't agree. Our clients. Right, defendants, that includes bias against defendants. They want nothing other than to take the person sitting next to you, put them in an absolute hellhole, and you can tell the jury that includes bias against defendants, and hopefully you'll score some points on that. You can plant concepts that you're going to use, talk about witness consistency that you're going to use during your cross-examination. Now you have to find jurors that are not going to be responsive and they're secret jurors. Here are a couple of ways you can do it. Do you use the words officers or cops? And if they use the word cops, they're probably more friendly. What news stations do you watch? And the chances are, if they watch a certain station, they may be more cop-friendly. Do you have friends or family in law enforcement? If they do, I would ask, so your cousin, Excuse me, juror number 6, you have a cousin in law enforcement. If you decide to acquit my client, are you going to be embarrassed to tell your cousin that? Juror number 9, your husband works in law enforcement. Are you going to be proud to tell him that you convicted my client? And this, I think, is paramount too. I may be rude to officers, ladies and gentlemen. Juror number 9. I may throw my notebook in my head. I may throw a pen. I may turn around. I may walk away while they're talking. I may be exceptionally curt. I have answers I have to get. That's my job. But if I'm rude to an officer, are you going to hold that against my client? Are you going to hold that against the way that you interpret the evidence? And hopefully they're going to get on your side. Now I'm going to talk about this probably a little too much for everyone, but I can't convey what I think the importance of this is conveying that officers are trained to testify. You have to make the notion that practice makes perfect. Now, some people like to say, talk about the first day you were at work. How'd you feel? You were nervous, you were scared. And several months later or years later, how'd you feel? Calm, cool, and collective. This is how I do it. Juror number 7, I have a hypo for you. Witness number A is calm, cool, and collective. Witness number B is nervous and fidgety and breathing fast. Who do you find more credible? I'll always say witness number A. All right, let me change the facts a little bit. Witness number A has been trained to testify. He's been trained to wear a suit or a tie. Sometimes he's been trained to answer correctly to the jury, and he's testified over 15 times. Witness number B has never testified in his life and has the values that we hold the most dear at risk. Now, with those facts, do you still find witness A more credible? And they'll work for you. Now, I'm going to tell a quick story. It's a Nan Whitfield story. I just got to tell it quickly about facing Nan. I'm a Nan fan. And it was about getting talking about officers who were trained to speak to the jury. Nan had an officer shooting case. I ended up with a civil case. And basically, it was a home invasion robbery, and an officer showed up, took a shotgun, blew away the first 2 black people he saw. Nan had the civil case, and it was going very well. And she asked the officer if he wanted to apologize. And he turned to the jury and said, "I'm sorry." And Nan said, "What are you talking to them for? The guys are right over here." And it was very effective and very poignant. I like to talk about commonly used fallacies by the police officer. Frequently they say totality of the circumstances. So I like to ask the jury, what does that mean? And it means totaling up the circumstances. Because I personally believe that a lot of officers say totality of the circumstances when they just don't want to answer any more questions. And they're blown away when you say afterward, you say, all right, totality of the circumstances. What circumstances? Excuse me? What does that mean? Excuse me? 2 things can happen. Either they can repeat all the circumstances, no harm, no foul, they've already told you that, or they can look incredibly foolish. High crime area. You can put up a map and say, hey, listen, they say it's a high crime area. So let's go over a couple of blocks, a couple of miles. Is that still a high crime area? Let's go up, it's still a crime area. And they're going to tell you that basically every area that's not populated by white people is a high crime area. There's another lawyer in LA, he does this fantastic thing where he says, all right, in this high crime area, aren't there more churches per capita here than there are in Westwood? And the answer is always yes. Aren't there more Bible study classes here than there are in, yes. So is it a high crime area or is it more of a heavily policed area? And I'm sure that's very, very, very effective. We have to start using race issues, if you're not right now, to identify and strike biased jurors. The system is inherently racist. It's our job to fix it. A lot of people have different ideas. This is one that's effective. Okay, all the jurors raise your hand. Here's a hypo. Some people believe that the African-American population is incarcerated much more than any other creed. Some people believe that's because the system unfairly targets this group of people. But others believe that's because blacks commit more crimes. So put your hands down unless you believe it's the latter. And if anyone fortunately keeps their hand in the air, you're being friendly to the racist jurors, you say, and that's going to be the case no matter what I say, the prosecutor says, the judge says, and if they say yes, you have a 4-cause challenge. Not only that, you may get we have a judge, Judge Mitchell, who will give a lecture in California, and that's very, very beneficial to your clients. And again, you can talk about witness bias. All right, here we are at opening argument. And you're beginning to, so I like to preview inconsistencies. Ladies and gentlemen, the evidence will show that the officer's testimony is simply not reliable. Is it at odds with other testimony? It is at odds with the evidence that you will see for yourself. It is at odds with the officer's own prior statements. Boom, 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 boom. But we got to be vague. We cannot disclose what the impeachment evidence will be. Why? Because they're going to fix it. Right, we can't give them time to prepare a response. Okay, again, I like to instruct that officers are trained to testify. This is the second time. The evidence will show that the officers took class in testifying. They've testified X times before. They've been trained to do this. They've been trained to do that because it bolsters their credibility. All right, so now it's time to start your cross-examination. What's the very first thing that you do? So here are three things that you have to do right off the bat. You're going to marry the officer to the report. You're going to convey the magnitude of that report. And you're going to establish that the officer was trained to testify. Officer, did you prepare a report in this matter ending in D1456? Yes. Is it truthful and accurate? Yes. Is it neutral? Yes. Did you include all the information relevant to the guilt or innocence of my client? Yes. Did anyone limit what you could write to that report? No. Did you review that report prior to testifying today? Yes. Did you discuss it with the prosecutor? Maybe yes, maybe no. Are there any changes that you want to make to the report now? Now, you know all the reports. You know their content, and you don't want to let them weasel out of it later on. So you have to show that that report is crystal clear in the way that they presented it. Next, you have to convey the magnitude of those reports. Because these reports have tremendous authority. They have incredible, incredible value. And we need to convey how important that value is. So I like doing it like this. An officer, you understand that that report can be submitted to a supervisor or a sergeant or watch commander or whatever it is in your jurisdiction. Yes. And that supervisor can submit that to a prosecuting agency. Yes. And that prosecuting agency, that district attorney can decide whether or not to bring a criminal action. Yes. And in fact, that's what happened here today. Yes. And now we're telling the jury that the reason they're spending 1 week, 2 days, however long it is not because of what your client did, but because this report that should be sacred, that's why they're there. Okay, they're there because your client, if he did it, he could have gotten away with it. But they're there because someone wrote a report about it, and now they've decided to commence a criminal action. Now, I think this is very, very, very dangerous. A lot of the forms for the reports are very messed up. This is a form that we use in Los Angeles for domestic violence. On one side it says victim, on the other side it says suspect. That's absolutely twisted. We're going to let a junior officer who's the first person at the scene without any investigation make a snap judgment call about who's the victim and who's the suspect. And that's going to start a chain. It's a domestic violence case. They're not going to dismiss it. And that's going to go all the way up into the trial. And all of a sudden the suspect is sitting in the defendant's seat. And the alleged suspect is right there. And that is so messed up because we should not be giving this power to certain officers. Okay, again, we're going to talk about, for the last time, you're going to say, officer, when did you attend the academy? 6 years ago. At the academy, you were trained to testify. You were trained to wear a suit or uniform. You were trained to speak directly to the jury. Use that one, some were that weren't. And you've testified how many times? Now the jury is ready to think, all right, is this a swindler? Or they're not going to go in the back and say, oh, he testified so well. You're going to find your voice because we have to. You know, there's no set voice you have to do. Just find yours and be ready to go. Now, I've gone a little slower than I have to, so I'm going to have to jump ahead a little bit. It's your show, and you got to control it. All right? During the beginning and up until an inconsistency or a lie or an answer or non-answer, you're controlling it. You're placing the officer at the scene. You're not asking any open-ended questions. You're going to introduce one fact per question, and you're going to speak in the past continuous tense and the present tense. And I didn't know how to define those earlier, so I found out on Google. But, officer, you were observing the corner of 5th Street and Olive, correct. From the empty lot at 4th Street and Olive, correct. You were using high-powered binoculars, correct. Your view is unobstructed. There's a check-casting store, blah, 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 blah. You're waiting for the time and the chance to deviate. You're listening, because this isn't a play. It's an improv. And you're going to have a million reasons to deviate. Officers may give you testimony that you don't expect. They conflict with prior statements. They may say things that are bizarre or evasive. Trust your instincts. If something goes weird, you know it's right. You're all here for the right reasons, so get ready to move. Now, Murder on a Sunday Morning was a fantastic movie. It started the whole making a murderer craze. It was by the same director, and it was about this 15-year-old boy who was wrongly accused for a murder, taken into the woods, and beaten by the son of the local sheriff, Nat Glover, and the I.O. did no work at all. This is Pat McGinnis, who's amazing, doing what I think is one of the best cross-examinations I've ever seen in my life.
Did you tell him that you would arrange for an attorney for him?
I said we could see if we could make arrangements for that.
Okay. Did you tell him you would arrange an attorney for him?
I said we can make arrangements for that.
Okay. Did you make the first arrangement?
No, sir, did not.
Did you pick up the phone?
No, sir.
You just told the young man at noon he had a right to an attorney, right?
Yes, sir.
And then you told him you'd arrange for one, right?
Yes, sir.
But you didn't.
That's correct.
You didn't take the first step on making good on that promise.
I didn't promise him, sir. I just made a statement to him. And
he
no, I
deviates.
did not make a phone call.
Okay. When you say, we'll arrange an attorney for you, that's not a promise?
I don't make promises to the individuals I'm interviewing.
I'm not sure I follow. If you say
said-
you're going to do something,
Yes, sir, but it wasn't said, it wasn't brought across as something I promise you I'll do. Or make it, it wasn't said, I promise you I will go do something.
so you only do it if you promise?
No, sir. You brought the word of promise.
Well, you didn't do it, right?
That's correct.
Would you have done it if you said, I promise?
Boom.
Well, I would have decided
Now,
when it got to that
the witness
point.
just stutters for the rest of the thing.
You knew less than 100 yards from where you sat, there was a courtroom in operation with a public defender, right?
I'm not sure the distance, but there was a public or a trial courtroom. Attorneys are there by the jail.
In retrospect, do you think perhaps you could have been more thorough and more competent in the investigation?
Perhaps, sir, it's always good to self-judge yourself. So you make sure you do a better job next time.
And that's a segue to talk about something important. Find a question, draft a question that's a perfect note to end on. That, couldn't you have been more thorough in your investigation? A question that sets up an inconsistency and you're sure the view of Fourth and Olive was unobstructed. I think if you got this personal information, you have to use it. Okay, you have to.
How tall are you, sir?
5'11",
What do you weigh?
240 pounds.
You played high school ball,
Yes, sir.
college ball,
Yes, sir.
played lineman.
Yes, sir.
As a lineman, you hit people.
Yes, sir.
You were on scholarship.
Yes, sir.
You hit people well,
Yes, sir.
and you hit them hard, right?
Yes, sir.
All right, now we've just shown that this officer who beat the crap out of a 15-year-old kid is a savage, and that's fantastic. In one case that I have right now, I have one bit of personal evidence. Here's what the officer is doing to my client. This is what my client looked like after that altercation, and this is what the officer looked like before joining the police force. And we're hoping to use this sort of information in a very compelling way to help out the civil case. I'm going to have to pass on my Ivan Guillermo story. I can't pass on this one. Medical story about an officer who killed somebody. In his medical records, he wrote, "This incident made me more racist," which meant he was racist to begin with. I got to ask him about it. I was like, and he's like, "Well, I'm not saying I'm a KKK member." I'm like, "I'm not accusing you of being a KKK. Their actions over the last couple of years, calling me out as being a white racist cop when I have biracial children, they were half Hispanic, makes me angry." Makes you angry at black people? Yes, but not black people everywhere. That would be the true racist. Black people in Milwaukee. That was horrific and fantastic. I'm not going to tell, questions that have no bad answer. One of the best examples, okay, I had Ivan Guillermo did this to my client, and my client was autistic, and asked a couple of women, "Hey, do you guys want to have casual sex?" And then they said no, and called the police, and Ivan Guillermo came and did this to my client. And so the question I wanted to ask him was, do you find these women attractive? Because if the answer was yes, it showed that he was trying to impress the women. Instead, he said, no, personally, I didn't find them attractive, and the jury just thought he was a dick. I fully agree. I'm not going to spend a lot of time with this, but questions you don't know the answer to, look, we in California, we don't get pretrial depositions. If don't be worried about asking a question you don't know the answer to, because you might lose, you might get burned, but chances are, your instincts are honed and you're smart. So go down those rabbit holes because chances are it's going to help you out. Avoid the aha moment. It's never going to work. It might have worked when you're practicing. It's not going to work out there because it's just not going to go. Be smarter, but don't look smarter. Okay, I'm going to pass on officers or experts, but just never challenge an officer's academic achievements. I was on one case, murder case, the gang expert came out, and the lawyer said, "You didn't even go to college, did you?" I mean, half the jury hadn't gone to college, so it was not that effective. Officers or experts, you can do a whole bit on that. So talk about that another time. Now, the best impeachment is none at all. I once had an officer who swore in a search warrant affidavit that a witness made certain statements which never happened. I brought in the witness, and she said she never made those statements. And so the officer, totally depleted, just repeatedly admitted to lying under oath. And it was very effective. The bad news is, good news, they dismissed the case. Bad news is, DA did nothing to the lawyer who admitted perjury. He got no internal reprimand. I brought a civil action, and the court threw it out on the eve of trial, claiming there was independent probable cause. So now you've got your dirt, and you've had a good time. Please share what you happened, because I mean, other lawyers are going to need to follow you, and if you've done your homework, let them do the homework too. Share it with any organization, your listservs, or the people that you know, please, because we need you to do that. All right, trust yourself. I mean, chances are you all could be making a ton more money somewhere else, doing something else in civil litigation or working for corporations, but you're here because you like people and you have this strong sense of humanity, and you like to protect the downtrodden against the forces of government. So just trust yourself, because if there's a rabbit hole and if your spidey sense is tingling, go down it. You're probably right. Now I'm going to show you something with some pretty horrific images right now. Please look away if you don't want to see them. But this work we're doing is really important. That's Dontre Hamilton in the bottom right corner as a kid. That's Dontre Hamilton ready to go out when he was a young adult. That's Dontre Hamilton after he met Christopher Manny. He was shot 15 times. That's Christopher Manny, who claimed that shooting Dontre Hamilton gave him PTSD. And so now he gets 75% of his salary tax-free for the rest of his life for shooting Dontre Hamilton as his disability payments, and he will never be prosecuted because John Chisholm does not believe he can convince 12 people that this man, this homicidal man, killed someone because of that shroud of reliability and that shroud of credibility. So lastly, make an impact. I mean, before Trump was president, the stories of these officer shooting cases were everywhere. You know, and then they sort of disappeared. Journalists couldn't control who turned the paper, who turned off the TV, clicked off a web page, never picked up the paper beforehand. They couldn't get in their audience's face. But you can. You have 12, 14, 6, depending on your jurisdiction, people in that box that have to listen to you. They can't leave at intermission. They're stuck right there. And if you can just get in their face and show them that officers are human and biased and prone to exaggeration and just whittle away at that shroud of credibility and reliability, then not only will your client be better off, but we all will. Thanks very much.